Good morning, dear students. Welcome back to our online class. So today we are going to start with the fifth chapter of the civics, High Court and Subordinate Court. Already we have seen in the previous video about the Supreme Court, and many of the functions are similar in the High Court and the Supreme Court. Okay, so this is also a part of the single integrated judiciary system which we have discussed yesterday. And in that Supreme Court is the apex court, and below the Supreme Court comes the High Court. Okay, and below the High Court comes the Subordinate Court. Okay, so let us see what is High Court. This is a picture of the High Court of Kolkata, and our UP State's High Court is at the Prayagraj, and the current Chief Judge of the High Court is Rajesh Bidal. Okay, so today let us learn more about the High Court of our country, that how the High Court functions, what is the appointment procedure of the judges, and what is the composition, everything. Okay, so the Constitution of India provides for the High Court for each state. That means every state is having a High Court. Okay, and Parliament may, however, establish a common High Court for two or more states. For example, or even for the Union territories. For example, Haryana and Punjab are the two different states, but their both capital is Chandigarh. So both the capitals share the Chandigarh High Court. Okay, that means the Chandigarh High Court is the one that is meant for both the states Haryana and Punjab. Similarly, we have like for Union territories also there are same High Courts. Now recently formed state Telangana and also Andhra Pradesh both share a single High Court, that is in Hyderabad, because the capital of both the cities are Hyderabad. So beside this, there are 25 High Courts in India, including those having the jurisdiction over more than one state. Okay, now among the Union territories come under the jurisdiction of the different High Court. Some Union territories also come under the jurisdiction of different High Court. Okay, so let us see what are the qualifications for the appointment as a judge of High Court. So with superior person of the High Court is a judge, like the superior person of the Supreme Court is the Chief Justice of India. So the qualifications are almost same. He should be a citizen of India. He should not be more than 62 years at age, and he should have held a judicial office of at least 10 years or worked as an advocate in a High Court 1, 2 or more for at least 10 years. Okay, so this is the basic qualification requirement for a person to become a judge, or for an advocate to become a judge in the High Court. Okay, then the qualification, he should have been distinguished jurist, which was added by the 42nd Amendment Act in 1976, and later it was been omitted in the 44th Amendment Act in 1978. So these are the basic things that you have to keep in mind. Number one, he should be a citizen of India. He should not have more than 62 years of age, and he should held a judicial office for at least 10 years or worked as an advocate in a High Court 1, 2 or more for at least 10 years. Okay, so these are the basic qualifications that you have to keep in mind. Now let us see what is the method or the appointment procedure of a High Court judges. Okay, every judge of High Court is appointed by the President in consultation with the Chief Justice of the Supreme Court and the governor of the concerned state. We know that every state is having a chief minister and a governor, and chief minister is elected by the general election every 5 years, whereas the governor is appointed by the president. Okay, so now for appointing a High Court judge of that particular state, it will be directly appointed by the president, but in consultation with the Chief Justice of Supreme Court, because it is the apex court and the judge holds the apex position of the Supreme Court, and the concerned governor of the state. Okay, so in case of appointment of the High Court judges, it is done by the President in consultation with the Chief Justice of Supreme Court. chief justice of that high court and the governor of that state. You remember when we discussed about the Supreme Court, we have seen that after the Supreme Court, chief justice of Supreme Court is being selected or appointed by the president, under his guidance the president will be electing 30 more judges who will be assisting the chief justice of India. Okay, and in a similar manner, after the appointment of the high court judges, it is done by the president in consultation with the chief justice of the so-called Supreme Court and the chief justice of the so-called elected high court and the governor of the state. All these together will be electing the assistant judges of the high court. I hope the point is clear to you. Okay, so next we will see what is the term of office of the high court judge. A high court judge can hold the office until he reaches the age of 62 years. Okay, and in the Supreme Court it is 65 years. Okay, so in case of resignation, the high court judge need to submit the letter to the president, not to the Supreme Court Chief Justice of India. Okay, so he has to directly submit it to the president. So this is the term of the office. Now let us see what are the conditions of service, that is removal, retirement, transfer, salaries and restrictions on the practice, etc. So first is removal of the high court judge. On what basis or on what grounds a high court judge can be removed? Judges can't be removed by the normal simple procedure. It's not like you find something wrong and ask him that write a resignation letter and leave. No, it's not possible. A judge of high court can be removed only by the president on the grounds of the proved misbehavior or incapacity. The very same point we have discussed when we discussed about the Supreme Court judge. Okay, you know, all these points are much similar, only for whether it is for Supreme Court justice, except few variations, many of the points are similar. And coming to the procedure of the removal and retirement, it is almost same. Okay, and even appointment. So approval of the 2/3 majority of both the houses is also needed to go ahead with the impeachment of the high court judge. Okay, that is removal of the high court judges. Judges can't be removed by normal simple procedure. Keep in the mind, they have to be proved their misbehavior in front of the president on solid grounds. Second is, for this approval, around 2/3 majority of both the houses of the parliament should put a signature or should give their approval to show that this person, this high court judge, can be impeached. Okay, then the retirement age of the high court judge can hold office until he can work until the age of 62 years. Okay, so we have already seen the term of the office. So still 62 years he can work, and after that he can go for a retirement. Now we will come to the subordinate courts. Okay, as per your reduced syllabus, there are so many things there. You can study about the salaries, emoluments, restriction and all, but it's not there in the syllabus, so it's not relevant. So next we directly come to the, even I just want to add the things that powers and jurisdiction of the High Court are same like that of the Supreme Court. Here also we will be coming across the original jurisdiction, appellate jurisdiction, and judicial review court, advisory jurisdiction, revisory jurisdiction, judicial review, court of record. All these we have done in the chapter Supreme Court. Okay, so here we come across through the which are the subordinate courts. Okay, so subordinate courts are the courts that function at the every district level and below that. Okay, means in the district, every district again has 3 different types of courts. Don't forget this. Every district have 3 different types of courts working under them, and that is why these courts are called as the subordinate courts. Okay, now first one is a civil court, that is the district court. Okay, second one is the criminal court, that is sessions judge, sessions court, and third one is a court of revenue. Okay, so keep this in your mind. First one is the district court, criminal court, and which is also called as the sessions court. Okay, and courts of revenue. Now in civil court, that is district court, almost all types of cases are taken, and it is at the higher level of a district, right? Then criminal courts are the sessions court where only criminal cases are dealt with. Okay, criminal cases are dealt here. Uh, then coming to the court of revenue, all the matters related to the revenue of the district will be discussed or dealt in this revenue court. Okay, so keep these things in your mind. Then it is very important to understand the difference between the district court, and who will be the chief judge of the district court will be the district magistrate. Okay, that we call it as a DM. Okay, district magistrate. So it is the highest civil court. District court or court of district judge is considered as the highest civil court of the district. Okay, so this is the very important topic that you have to learn, and you have to learn as it is. So when it is the highest civil court of the district, and district judge is, it is presided, district court is presided by the district judge. Okay, now the district judge and the additional district judge, okay, in it is also called as district magistrate, that is why we call DM, and additional district magistrate, that is ADM. Okay, and we also use SDM. Okay, these words, so that every state use a different degree of, or abbreviated form, but almost have the same meaning. So ADM or SDM. Okay, so the district judge, that is DM, and additional district judge ADM are appointed by the governor in consultation with the Chief Justice of the High Court of the concerned state. Now, the Chief Justice of the High Court of Uttar Pradesh is in Prayagraj, and the High Court Chief Justice is Mr. Rajesh Bindal. Okay, so with their consent, the every district's DM will be decided and appointed. Okay, now this district court of justice actually handles all the civil cases like cases related to land, property, marriage, divorce, will, etc. Okay, now district judge also acts as deputy commissioner and district collector. So the every district judge is also given the duty or the responsibility as a district collector, that is DM, we say district magistrate, and maintains law and order and supervises the collection of the revenue and taxes in that particular district. This is what is a function or the duty discharged upon a DM. Okay, so a DM is responsible to maintain law and order. A DM is responsible to supervise the collection of the revenue and the taxes in the district. Okay, now maintaining law and order means in every aspect, in every sphere of the activities of a district, the DM is responsible for maintaining that. Now let us come to the sessions court. Sessions court is called as the highest criminal court of the district. Okay, criminal court where all the criminal cases are dealt in the sessions court. Okay, usually this is presided by the sessions judge, or it is also called as a district judge. Okay, now the sessions court deals with the cases concerning very serious offenses. Okay, it handles the cases, criminal cases like murder, theft, dacoity, pickpocketing, okay, and rape cases. All these cases are dealt in the criminal courts. Okay, then it is mandatory that a sentence of death must be confirmed by the High Court before it is carried out, irrespective of whether an appeal is made to the High Court or not. Okay, so in the sessions court, it is very mandatory that the session judge and the additional session judges, okay, that is DM, session judge means DM, district magistrate, and additional sessions judge means ADM, are appointed by the governor of the particular state in consultation with the Chief Justice of the High Court of the concerned state. Okay, so the sessions judge does not perform any administrative function. Okay, here a sessions judge who is appointed as a sessions judge, he is not responsible to perform any administrative functions, whereas the DM who is appointed as a court of district judge is responsible to perform the administrative function. That is why they are designated as in IAS officers or Indian Administrative Service, those who have cleared it. Okay, and they have worked in many places. So this is what we have to learn, the main difference between court of district judge and the sessions court. Okay, now next we will be coming, now let us see what is the court of revenue. Court of revenue is actually, it's not there in your syllabus, but just I am explaining you in detail that you have to keep in mind. One is that board of revenue. Board of revenue means what? It is the highest authority where the revenue of the state, that is the tax collection is done. Okay, and matters related to land and property are all dealt in this revenue court. Okay, and this is also having different subdivisional like commissioners court, collectors court, tehsildars court, and naib tehsildar court, etc. Okay, now what are the role of this? Tehsildar is responsible for the collection of the revenue and property taxes assessed by the Naib Tehsildar. So at the lower level is Naib Tehsildar, and Naib Tehsildar's court, this is the lowest court, and Naib Tehsildar hears the cases relating to the assessment and land revenue property taxes from the farmers, okay, in the villages, and appeals their assessment can be taken to the Tehsildar. Okay, if that is not solved by the Naib Tehsildar, he will be asking them to appeal to the Tehsildar. Okay, a Tehsildar will be one level upper than the Naib Tehsildar. And Tehsildar's court is responsible for again collection of the revenue and taxes assessed by this Naib Tehsildar. Okay, now collector's court. The court is generally headed by the deputy commissioner of the district, and he helps the revenue department in the process of the assessment and collection of the revenue, in addition to its original duties of the administrator of the district. Now he hears all the appeals that have come in the Tehsildar in the collector's court. Okay, means you have to remember at the like a pyramid, if you will think, you will at the lower level is Naib Tehsildar, then comes the Tehsildar, then comes the collector's court. Okay, and above that comes the commissioner's court. Commissioner generally has 3 to 4 deputy commissioners appointed under him, because everywhere it is not possible for the commissioner to go and check. So he looks after the assessment and collection of the revenues of all the districts in a particular division. Okay, now above this commissioner's court comes the board of revenue, which is placed mainly in the state, and this is considered as the highest field of the revenue. Okay, so this is what about the revenue courts. Now let us come to Lok Adalat. Lok Adalat, from the name only it is very clear. Lok means what? It's people. Adalat, court. Okay, so that is why it is said as Lok Adalat, means people's court. And Justice P.N. Bhagwati, Lok Adalat were set up in 1897, and it was set up to provide legal help and quick justice to those who can't afford expensive fees of lawyers and expenses of legal proceedings. Okay, this is like it's like a fast track. Today we have the fast track codes also. Okay, and Lok Adalat is actually an initiative of today's fast track court. So Lok Adalat means people's court, wherein people who can't pay huge fees to the advocates for solving their cases, especially the people under the poverty level, the poor farmers and poor workers, etc. The common people, common means commonly common people who are at the very underprivileged category. Okay, so these type of people, actually they can approach this Lok Adalat and for solving their matters or issues. Okay, now decision of the Lok Adalat is considered as a decision of a civil court. Now whatever decision is given by the Lok Adalat, it is given that power that whatever decision it is given by the judge of that Lok Adalat, it will be equal to the decision of a civil court, means that importance is same. They are organized as a convenient places like factories, farms, commercial complexes, and neighborhood of the litigants. Now, Lok Adalat, where it functions, there is no particular office space or building like High Court or Supreme Court for the functioning of this, or District Court for the functioning of this Lok Adalat. Okay, so they organize any convenient places for the factory workers in a particular factory or nearby a factory or in that industrial area, or for the farmers in a particular farming area, or okay, so or any commercial complexes, etc. Now, cases are handled informally involving both the parties and disputes, and are settled in a spirit of harmony and compromise. So what is the first step of this Lok Adalat? Is to solve the cases out of the court. Okay, now out of the court is what? To call both the parties together, give them counseling, guidance, advices and all, and after that trying to make compromise or settle the disputes outside the court by making them the understanding of the haves and have nots, consequences, etc. Okay, now those cases that have been handled by any other court are also sometimes handled by the Lok Adalat. Now, any other court means which court? Okay, it can be a revenue court, it can be a Naib Tehsildar's court, it can be a Tehsildar's court, or it can be even a sessions court. Okay, so it again they can come outside the court and they can have a compromise. Suppose sometimes, many times it sees that people in vigor, in josh, they go and file a case against each other, and for after hearing one or two trials and all, they feel like it's better to make a compromise, and they come out of the court and they approach these Lok Adalats to make a compromise situation or settle out of the court. Okay, so now how this working of Lok Adalats, let us see. That is, the judges, law graduates, public workers, social workers inform the litigants about their rights and duties. Okay, now what is it's not the people who actually serve in the Lok Adalat or work in the Lok Adalat, or where all the legal authorities, they all have the knowledge and experience from the law. Okay, so they might be law graduates, okay, advocates, law graduates. They might be retired judges, the retired judges of High Court. They cannot if they want, they cannot practice. Okay, so these retired judges of the High Courts, or law graduates, or even public workers. Okay, public workers here means those people who are in the field of social working and NGO, non-government organizations, who are also familiar with certain laws of their society in which they are dealing. For example, a NGO running orphanages, they have the laws and rules, they have the knowledge about for the adoption or such type of issues. Okay, so these type of public workers or social workers, they inform the litigants about their rights and the duties. In our country, in India, many of the common people, even we take ourselves, we doesn't know the basic rules of the that is been basic rules at the ground level. Also, we are not aware of the things. Okay, and I think that as a human being, as a citizen of country, from the early age itself, means the students studying in the early age itself, they should come to know about the various Indian Penal Code sections, and also the basic laws that are meant for the people, so that they stop themselves from getting in problematic situations, or sometimes taking action, strong decisions for the right things, etc. Okay, so this is the duty of these Lok Adalat people, that they have to make awareness program, social workers, NGOs, etc., for knowing the people about their basic rights and the duties also. The judges of the Lok Adalat are actually counselors. They actually act as a counselors, and these adalats are assisted by the legal aid committees and social action groups. The first Lok Adalat, you have to, it's very important. That's why it's marked in 3 stars. You can see the first local Adalat was held at Junagadh in Gujarat on March 14, 1982. Okay, so It's very easy to remember for me. I don't know for you, you will remember or not. So March 14, 1982 in the Junagadh, Gujarat, the first Lok Adalat was held. Okay, so don't forget this. So then we will come to know the different types of the Lok Adalats. Okay, now both the parties, what are the advantages of the Lok Adalats? Let us see. Lok Adalats play a very important role in the settlement of the family feuds. Family feuds means family issues or matters, disputes between the neighbors, for example, related to the property or related to the boundary of the property, land, etc., or any other case of disputes. Okay, and minor cases of assault and injury by setting the disputes through compromise. Since the Lok Adalats work in the spirit of compromise and understanding, both the parties are very much satisfied. Now, Lok Adalat also delivers fast and inexpensive justice. For it's very cheap in price, that you don't have to pay very huge price to the people there, okay, the advocates there, or the whomsoever you are concerned with. Okay, and the decisions will be, they don't in the, it's difficult, it's different in the court and Lok Adalat. Lok Adalat is like, in very short span of time the things are decided and finalized, whereas in courts it takes a very long time consuming process. Okay, so Lok Adalat reduces the workload and delays of the others, like certain matters related to getting an NOC. Suppose I am going to construct a home and I have to get an NOC, then I have to meet the concerned people, get the NOC. NOC means no objection certificate. Okay, so things are done very fast and quick. It's not like you have to wait for a 1 week or 5 week or 6 week or a month, like that. Okay, so the speedy actions are done. So today we have fast track codes also, where more speedily, because of the technological advancements, these fast track codes also work and get the results fastly. So next is that providing legal aid to the weaker sections of the society. Lok Adalat mainly focuses on not those people who are financially sound and who have good hold and power in the society. No, they mainly focus on the legal aid, that is to give the legal help to those weaker sections of the society who could not afford high lawyers and all. Okay, then these are the, and both the parties, any issues and disputes, both they will, through the compromise method, both the parties will be satisfied. Okay, and Lok Adalat also promotes the social justice by providing legal aid to the weaker section. So it more than seeing on the religion, caste, creed and power or position, it tries to get justice to the weaker sections. Okay, so it reduces the workload of the courts. Now, another important advantage of the Lok Adalat is that if many of the minor cases are sorted outside the court through these type of Lok Adalats, then the court will be not having much burden of the cases. Okay, so now Lok Adalat, this is what is the advantage of the Lok Adalat. So types of Lok Adalat is there, it's not there in your syllabus, so I am not discussing on that, but you can have a read in your textbook. It's like National Lok Adalat, Permanent Lok Adalat, Mobile Lok Adalat and working of the Lok Adalats. Okay, so we have beside this the family courts. Okay, mainly for compromising and solving the matters related to the marriage disputes, divorce, etc. Okay, so and also for the welfare of the people. So I hope that you understood this much point. So what are the topics there in your syllabus that we have discussed through this video? So by this we come to end of this chapter, and thank you for watching. Have a good reading, good time.